Good morning, Mr. Yana. As I've told you the other day when we were on the phone about my situation, may I know my rights and liabilities on this matter, Mr. Yana?
Hi, good morning, Miss Mark. Yeah, sure, of course, you may know your rights and liabilities on this matter. But to begin with, we will go first by understanding the concept of breach of trust, okay?
Alright, Mr. Yana. Can you please enlighten me on that?
Sure, Mr. Mark. So basically, a breach of trust is a failure for the trustees that have been appointed to act in executing the duties imposed to them. A trustee can only be held liable or can be held accountable for breach of trust if the breach led to an unauthorized gain for the trustee or a loss for the trust. The beneficiary or the aggrieved party can bring legal action against the trustee if there has been a breach of trust. So the idea is that a trustee may be held accountable for breach of trust if he doesn't carry out his responsibilities or his liabilities as a trustee.
Understood, miss. May I know any types of breaches that present? Also, which one of the breaches is relevant for my case, Mr. Yana?
So generally, there are three types of breaches, which are breaches that occur before the appointment of a trustee, breaches that happen during the trusteeship, and also breaches that happen after the trustee's retirement. So basically, for your case, the relevant one is the breach that occurs during the trusteeship.
Ah, I see. Can you please get into details regarding the case that I am having right now?
Sure, Mr. Mark. So now we will go in details on this matter. Basically, a breach of trust can occur in two situations where a breach could result from either the trustee's own actions or those of his fellow trustees. The beneficiary may generally bring a lawsuit for a breach brought on by the trustee's own negligence, even if it is only a minor breach and the trustee is at fault. The concept of Section 35 is to provide protection against any action of breach committed by the co-trustee. However, there are several circumstances by which the trustee can be held jointly liable and not entitled for the protection under Section 35 of the Trustee Act 1949. In the case of Booth and Booth, it was held that if a trustee has the knowledge that another trustee is contemplating for breach and did nothing to prevent it, he can be said to have committed to breach as well. A different view can be seen in the case of Boardman and Mosman. If the trustee tries to conceal any breach which was caused due to his willful default, he would not be protected under Section 35 of the Trustee Act 1949. The concept of which is highlighted in the case of Booth and Booth is similar to another form of breach of trust, which is liability of passive trustee. In the case of Rui Haji bin Haji Muhammad Noor, the court held that passive trustees may also be held liable for any failure of taking any reasonable step to prevent such matters.
Understood. But may I know how this provision is relevant to my current case?
In this case, Mr. Mark, you found that Mr. Harry violated his fiduciary duty when he took money from the trust fund early last year, which he used 50,000 ringgit of it as a down payment for his parents' newly purchased home 2 weeks later, and then took another 50,000 ringgit to buy shares in his wife's name on 1st August, where it now served as a value of 80,000 ringgit. Throughout the time, you and Mr. Harry served as a trust fund's trustee. He also spent 30,000 ringgit on a family vacation to Italy on 15 August and gave 10,000 ringgit to an elderly home a few months after. Even if you are protected from personal liability by Section 35 of the Trustee Act, there are still a number of issues to consider with, particularly in relation to Mr. Mark's knowledge discovery.
Okay, so adding on, may I know whether or not I would be liable in these circumstances? Because my co-trustee Harry committed the breach, not me. Thus, he is responsible for the breach. I just recently became aware on the situation. It's okay, let me handle it from there, Mr. Anna. Okay, thank you, Mr. Mark. In response to your inquiry, Mr. Mark, the Townley and Sherborne case does establish that a trustee's obligation is personal and not vicarious. The trustee is solely accountable for his or her own action and not those of other trustees. For example, Mr. Mark, I give you, while he is not responsible for another trustee's breach, he may be held liable for his failure to prevent such a breach. This is because, unless otherwise specified, the trustees must work collaboratively to manage the trust. Accordingly, a trustee may be held liable for his own or her own faults, such as passivity, enabling other trustee solely control of the trust property, cooperation or concurrence, as discussed in the case of Bryce and Stroke, 1805. According to Rihaji Ali case, uh, referring to the case Hafsah and Muhammad Zain, 1933, a trustee who is inactive or even a sleeping trustee is liable for the action of his co-trustee. Regarding your case, there were three trustees, one of whom was a semi-literate woman with little or no business experience. One of the trustee perpetrated a number of trust violence. The court determined that the actions of the trustee with limited literacy were justifiable because she was acting honestly and reasonably, but that the other trustee who was well versed in business but played no significant role in management of the company was equally responsible for the default. If a trustee does nothing to prevent a co-trustee from dissipating the trust estate, the trustee will undoubtedly face legal consequences. Therefore, despite the trustee's personal obligation, they have a duty to administer the trust fairly, and failure to do so will subject them to liability towards the beneficiaries. In addition, Mr. Mark, as stated in the case Bahin and Hogus, 1886, a trustee is liable for the action of his or her co-trustees, even if he or she did not commit the breach. As each trustee is responsible for administering the trust, this means that a beneficiary can sue one or all of the trustees in breach jointly or individually to recover the total amount of damage sustained.
Yeah, definitely, Adam. As Mr. Adam has been explaining on the potential liability that you may face just now, so now let me add on other things that you should know. So, according to the case of Townley and Sherborne, a trustee's commitment is considered personal and not indirect liability. In other words, you would be responsible for your own conduct and not for Harry's conduct. Even though the breach was not directly your fault, as a trustee, you could still be held accountable for failing to stop it from happening. According to the case of Bryce and Stoke legal case, you can be held accountable for Harry's misappropriation of the trust assets if you don't take any action to stop him from doing so. This is especially true considering that you knew Harry had previously taken money out of the trust and transferred it to his personal account, but did nothing to stop it from happening again. According to the case of Hafsah and Muhammad Zain, if you do nothing about this situation, you could be considered a sleeping trustee and held accountable for your conduct. Additionally, the Bahin and Haq Hayes legal decision case showed that even if you did not personally conduct the breach, you could still be held accountable for its effect if you knew your co-trustees' acts.
According to Section 63, if it appears to the court that a trustee, whether appointed by the court or otherwise, is or may be personally liable for any breach of trust, whether transaction alleged to be a breach of trust occurred before or after the commencement of this act, but has acted honestly and reasonably and ought fairly to be excused for the breach of trust and for omitting to obtain the direction of the court in the matter in which he committed such breach, then the court may relieve him either wholly or partly from personal liability for the same. The onus of proof test rests on the trustees to show that trustee had acted honestly without selfish motive or that he had thought genuinely further the interests of the trust, reasonably had exercised the degree of prudence expected from a reasonable man of business in handling his own affairs, and ought to be fairly excused. Fairly is to imply the fairness to both the trustee and to the affected person. In the case of Marsden against Reagan, in Rajabali, Jumaboy and others against Amirul Ali R. Jumaboy and others 1998, the Singaporean Court of Appeal granted relief to the trustee pursuant to Section 63 of the Singapore Trustee Act 1985 on the basis that they had acted both reasonably and honestly in executing a share swap. In fact, the factors that influenced the court decision were that the act was carried out with professional advice, with the consent of all of the relevant parties, with the intent to benefit all of the beneficiaries.
I'm sorry, but how was that relevant to our case or my case, Miss Nazira?
Applying to Section 63, you can show that you acted in honest, reasonable, and fair manner in relation to the breach of trust. However, the court will finally decide whether you should be totally or partially released from personal liability. As stated in the case of Marsden against Reagan, you will bear the burden of proving that your acts were reasonable, that you exercise the amount of care that will be expected, and that you should be exempted from culpability. In the matter of Williams against Byron, depending on the circumstances, the court may or may not provide relief from the personal liability. However, the court will only do so in extreme circumstances, such as when establishing culpability will be unjustifiable despite the occurrence of a breach. To success in this defense, it must be demonstrated that you exercise the bare least of care. Otherwise, the court may be less inclined to forgive you. As a trustee, you must establish that you behave in good faith and in a reasonable manner by treating the trust money with the same care that you would your own.
Oh, thank God. Now I have a complete understanding of my potential liabilities and defenses. Nevertheless, may I inquire whether Harry's breach on these situations trust entitles beneficiaries to any remedies?
Hi Mr. Mark, my name is Aminul and I will be explaining to you the available remedy to the beneficiaries in your case. I can guarantee you, Mr. Mark, that a tracing remedy is available to the beneficiaries. The definition of tracing as an equitable remedy is the right to track the trust property. In order for a beneficiary to be eligible for the equitable remedy, three conditions must be met. The first condition is that there must be an original fiduciary connection. Second, the trust property must still be in a trustable form. And the last one is the tracing of the property must not lead to an inequitable conclusion.
Aminul, could you please provide any further explanation on these three components that you have stated?
Mr. Mark, I'll be more than happy to elaborate on these elements. The first element is that there must be an initial fiduciary connection between the trustee and the beneficiaries. Firstly, Mr. Mark, it must be demonstrated that such a relationship exists, which may result from either a constructive trust or an express trust. If we refer to the case of Free Hallis Estate 1880, in the absence of a trust, the issue of tracing does not arise. As a remedy, Mr. Mark, tracing is only available after the formation of a trust. Moreover, in the case of Re Diplock 1948, it provides that additional clarification of this principle by stating that any subsequent relationship between the fiduciary and the person in possession of the trust property need not be a fiduciary one, so long as the original fiduciary relationship has been formed. Lastly, Mr. Mark, according to the decision in Sinclair and Brougham 1914, tracing is actionable against a third person without establishing a fiduciary connection with the beneficiary if custody of the trust property has been transferred from the trustee to a third party. If money from a trust fund was handed to a third party, and that money was accepted in good faith and was not used to pay for services such as a restaurant or a hotel, then the property would be considered traceable. Money held in trust that is used to buy a real estate, for example, it is considered traceable as long as the property has not been destroyed. However, if the money was used to buy shares, then the transaction would be untraceable because intangible property cannot be physically touched. In addition, if the trustee makes a transaction using trust assets that later turns a profit, the trustee is not entitled to keep the profits regardless of whether it was earned through a mixed or unmixed funds. This is because it is the trustee's obligation as a fiduciary to ensure that none of the trust assets are used to advance the trustee's own financial or other personal goals. Moving on to the last component, if providing the beneficiary the ability to trace will result in an inequitable outcome, the court will deny the equitable remedy in question. Therefore, it will be inequitable to award the remedy of tracing to the beneficiary if a third party, which is the innocent volunteer, had made a legitimate transaction using the trust property, which is the trust funds. In the case of Reedy Plot 1948, it was explained that the compelling an innocent volunteer to sell land that he had purchased with trust funds and that was registered in his name would be unjust. But if the trustee signed the money, which is the trust funds, to an innocent volunteer to purchase land that will be registered in the trustee's name, it will be equitable for tracing to be allowed and provided to the beneficiary, which is to accept the bulk land or property.
Okay, so how exactly do you intend to apply this to the circumstances of my case that I'm going through right now?
So, Mr. Mark, alright. So, looking at your case, first and foremost, obviously, Mr. Mark, Harry, your co-trustee, had put part of the trust funds into his own bank accounts. And the trust assets were used for things such as down payment on the house for his parents, the purchase of stocks, a family trip, and a charitable donation. And he had served as a trustee alongside with you. Referring to the case of Sinclair and Brockham, it had that under the circumstances, which is your circumstances, a fiduciary relationship is unnecessary. Moving on to the second element, which is the trust property must be in a form that is traceable. Since Harry transferred 250,000 ringgit from the trust account to his own bank account, which is already contained 50,000 ringgit of his own money, it is clear that the funds in the questions are a combination of his own funds and the trust property. Thus, citing the case of Rehallis Estate, the beneficiary would not be allowed to receive the property in its whole because it was not purchased exclusively with the trust money and was instead intertwined with Harry's own funds. The fact that Harry put a 50,000 ringgit down payment on his parents' home demonstrates that he used the trust funds toward the acquisition of an easily traceable asset. This beneficiary can only place a 50,000 ringgit charge on the home Harry bought with the mixed funds. Since Harry only used the trust's intangible property to buy shares, take a family vacation, and make a charitable donation, none of this spending can be traced back to the trust, given that the mixed fund the shares came from is now worth 80,000 ringgit. Harry will not be able to pocket any of the profit. Finally, yet importantly, Mr. Mark, the third element, which is the tracing of property, must not lead to an inequitable result. Here, the trust money used by Harry as a down payment in a house for his parents is not known whether the house was registered under his name or his parents. If the house was registered under his name, it will be equitable for tracing to be allowed and granted to the beneficiary to take the house. However, if otherwise, the court could not grant the remedy. In addition, regarding the share purchase using his wife's name, we show that the wife is the innocent volunteer, it would be inequitable to grant the remedy of tracing to the beneficiary. Are you clear with the explanation, Mr. Mark?
Thank you so much, everyone. I am very clear about all that you guys had explained to me just now regarding remedies, clarification of the claim, and I also for what we call breach, liabilities, and defense for my issue. Without further ado, I shall proceed with my suit to take action against Harry for his action of breaching the trust. Thank you very much, everyone.
In conclusion, since Harry has breached his fiduciary duty as a trustee and you, Mr. Mark, is his co-trustee, to your defense, you can rely on Section 63 by demonstrating that you had acted honestly, reasonably, and fairly in regards to the breach of trust. On the beneficiary's part, since the elements of tracing are not fulfilled, therefore the remedy cannot be used.